yourself for an in-camera examination and then make a ruling as to whether or not those should be produced to the defense.
All right, what's this state?
Well, Your Honor, the defense has to show particularized need to disclose the grand jury testimony for basically two bases as alleged in this case. The first is inconsistent statements. So if there were inconsistent statements presented in any portion in the case, to disclose the testimony of the witnesses who would have testified at the grand jury to see if there's any impeachment there. The other one is in the interest of justice or due process, and I think the defense has not alleged that in their particular motion in the case. Just relating specifically, Ms. Heinrich did not testify. The interesting thing about Ms. Heinrich's testimony is she, in fact, did not outcry that she could identify Dr. Kosowski until she was here for the Arthur hearing. She actually stood in this vestibule looking through the glass, and she told me in a very colorful way that she had identified Dr. Kosowski as the person that was in the closet the week before that she chased out of the building. I immediately disclosed that to Mr. Brunvaughn using a direct quote from Ms. Heinrich in the colorful language. I said, here's the disclosure. She said she can identify your client. That's the first time it came up. That was July, I believe, of 2023 when we had the Arthur hearing. Very much after we had the grand jury hearing, and she didn't testify there. As it relates to Ms. Bacher, as alleged in the motions to suppress as filed by defense counsel relating to the search warrants, one of the material omissions that's alleged by Ms. Bacher is that she took a photo pack, and the suggestion is that she did not identify the defendant. While it is true she did not overtly identify Dr. Kosowski, what she did say is it's maybe the person I saw, or there's a chance it's a person I saw. She was definitively no on 4 other people, and then on another one she said could be or chance. All right, so there is no suggestion that she eliminated Dr. Kosowski. In fact, it's the opposite. She said maybe or it could be. As it relates to the testimony,
Did she appear at the grand jury?
she did not appear at the grand jury.
Okay.
Chad Summerfield did appear at the grand jury. He is the DNA analyst in the case who did the initial work in the DNA. That was any reports that would have been pre-April 27 when he would have testified is what he would have testified to as it relates to DNA. I'm not sure whether the smear that was Dr. Kosowski's DNA, which was on the outside of the bathroom door, had been discovered at that point. I think it had been ongoing, and there was many tests being, an analysis went on for really months after that fact. And Detective Lance Moore did testify at the grand jury. A PowerPoint presentation he presented was actually disclosed to the defense counsel. I don't know if it was the same day as the grand jury met. Maybe it was the following day or the following Monday after they had met, but defense in the initial discovery received the PowerPoint presentation he utilized. And Colin Bolton did testify. He testified at the hearing as well. It wasn't at length. It was as to his ability to find out information about Mr. Cozzi and whether Mr. Cozzi had returned home between March 21st of 2023 and April 27 of 2023. So I think in the interest of justice, there's nothing's been raised as it relates to the disclosure of the grand jury transcripts. Going back to the inconsistent statements, one thing that's unique about this case is there are pages and pages of search warrants that have been filed and executed and disclosed. There are pages and pages of affidavits which were provided to this court, incorporated as an exhibit for the Arthur hearing. Interestingly, those affidavits are the witnesses that testified at the grand jury. Interestingly, Deborah Heinrichs testified at the Arthur hearing. Ms. Bacher has never testified in any hearings, but we've had an affidavit from Detective Moore. We've had an affidavit from Detective Bolton as it relates to the Arthur hearing. And they've all been deposed. Everyone's been deposed. 95% of the witnesses in this case, maybe more, have been deposed. There's been no allegation anywhere that they've testified inconsistently in any of those forms from March 21st to present day. So I think as it relates to the threshold showing of even disclosing the grand jury testimony, I'm not sure it's been met beyond a mere fishing expedition. However, I will say, Your Honor, if you are inclined to grant it, the in-camera review is a condition precedent before anything is released. And I believe you are uniquely positioned by having access to all these affidavits that have been entered into evidence, and also the search warrant affidavits that have been at least disclosed as it relates to the motions to suppress, to make that finding in this case. The depositions also, I believe, were all filed, or mostly filed, on the 25th So those documents are in the court file, and they're available for the public to view as well as yourself. That's all I have, Your Honor.
All right, thank you. All right, anything else from the defense?
Just, Your Honor, that I respectfully disagree with the state's position. We disagree with his rendition of the identification process when my client is not identified. And the fact that the state just now went through all the particular facts that we have raised supports the fact that it's not a fishing expedition. And quite frankly, in a case where the state of Florida is seeking the death penalty, the idea that Your Honor should not be able to review a few transcripts, I believe maybe there's only about 4 transcripts of witnesses from the grand jury, to evaluate whether or not there is information in there that's exculpatory or that, in the interest of justice, should be shared with the defense. And so we're asking the court to do the in-camera review and then rule on the issue once you've had an opportunity to review it.
All right, well, as we all know, the general rule is that grand jury testimony is secret. There's no pretrial right to inspect grand jury testimony as an aid in preparing a defense. To obtain grand jury testimony, a party must show a particularized need sufficient to justify the revelation of the generally secret grand jury proceedings. I do understand that I could order an inspection of them and then see if there's anything that's helpful in there. Probably the most relevant issue here is Deborah Henricks, but there's a couple of issues there. Number one, she did not appear at the grand jury testimony, so we really can't say that she said anything inconsistent at the grand jury because she wasn't even there, right? And then there's really not even an allegation that she's ever said anything inconsistent. The first time she said that she could identify Mr. Kosowski was when she saw him in person. There's really nothing inconsistent. She never indicated that she could not identify him. She never misidentified the person that she saw on March 14. She was never shown a photo pack and then said that she could not identify him. As a matter of fact, the Largo Police Department didn't even show her a photo pack because they thought she wouldn't be able to identify him because he was wearing a mask at the time. And then when she was here, apparently at least she said that she could identify him. So there's not going to be anything inconsistent. And then, of course, as the state pointed out, there's really 2 relevant reasons why the defense might be entitled to grand jury testimony, and that's ascertaining whether it is consistent with the testimony given by the witness before the court. So that's really not an issue for her. And then the other one is in the furtherance of justice, and that usually involves other things besides something like this, but it could involve something like this as well. As far as Carol Batcher, apparently she was not able to identify the defendant in a photo pack, and she may have said, well, it could be him, but I'm not sure. But regardless of whether she just couldn't identify him or she said it could be him but not the others, really doesn't make a whole lot of difference at this point. She didn't testify at the grand jury either, and none of that's inconsistent because she didn't take the stand at the Arthur hearing or anything else and say yes, I can identify him. So there's really nothing even allegedly inconsistent there. And as far as the officers, there's really a lot of speculation here as to maybe they said this, maybe they said that. And you know, even if they did say this or they said that, it doesn't make a whole lot of difference. I mean, I'm noticing that the defense is making a big deal if there was a whole bunch of blood or a little bit of blood. Apparently one of the officers, we thought there was a whole lot of blood. Apparently there wasn't all that much blood. I guess it's a judgmental thing about how much blood there is, but the fact is there was blood in there, and I think the DNA analysis came back to the victim, at least some of the blood. So I'm seeing a lot of allegations that, well, possibly the people who did testify at the grand jury possibly may have misstated things, and then possibly this may have misled the grand jury. But if you look at the allegations as to what they possibly may have misled the grand jury about, first of all, that's pure speculation if they did or not. And second of all, it really doesn't make a whole lot of difference in regard to what the allegations are. It's kind of like a Franks versus Delaware analysis. Even if we assume all this speculation is true, it's still not going to make any difference. And by the way, I didn't see any cases that said that if the grand jury was misled, that there's some sort of remedy for that, and you're really not advocating that if all this is true, that there may be a remedy for that. There is a case that I saw, of course, you really can't appeal until the end if the defendant gets convicted, but I did read one case where the defense alleged just that after the defendant got convicted, and then the court said, well, that issue is just that there's enough to charge the defendant, and he went to trial and he got convicted, so it's a no harm, no foul kind of situation. I didn't actually print that case out, but I did read that. But there's really no case law, and there's no allegation here that if they did mislead the grand jury, that there's some sort of remedy here. But I don't think there would be anyway, because as I said, under Franks versus Delaware analysis, even if all this speculation, and it is speculation, by the way, that they may have said that there's a lot of blood when there's really just a little blood, and these other things that you have, it's really not going to make a difference as to whether or not there's enough to charge the defendant in the case. So in an abundance of caution, quite honestly, I would grant your motion to have me inspected, because I think in death penalty cases, the smart thing to do is to always grant things in abundance of caution. But quite frankly, I don't even think this is close, so I'm going to deny the motion.
And Your Honor, if I could just add very briefly to that.
Okay.
I understand the court's position as it relates to that it may not make a difference as far as probable cause and what have you. But where it might make a difference is if statements are made by detectives in front of the grand jury, which I don't believe the state remembers exactly what was said. If they made statements, for example, about the observations of blood and what have you, that are incorrect or that are inconsistent with what they've said in depositions and other testimony, I have no way of knowing that. Okay, the transcripts are available for both the hearing and the depositions. The court would have an opportunity to see that, and if it was there, whether it's the court or the state that would review it, because that would be relevant information for impeachment purposes. It's not just about whether or not there's sufficient information for probable cause. It's also about whether or not there's sworn testimony that is available that might in fact be something that, whether it's Brady or whether it's information that would lead to proper impeachment of very important witnesses. So I think that's another consideration to.
Well, again, it's speculation. Why wouldn't that be the case in every single case then, right? Because there might be something that's inconsistent in what they said in the grand jury, as opposed to what they're going to testify in court. So then, would that be the rule in every single case?